everyone. Welcome to the Spicy Divorce Party Planner TV show. I'm your host, Spice, and today I'm really excited. We have an attorney with us, Jarrod from Oxendine Law, and we also have my gorgeous and wonderful friend, Tani, hi, my co-host. So we're really excited. This is our first attorney. And Jarrod, can you tell us what city you're representing?
Hey ladies, thanks for having me on. Looking forward to the interview. I actually practice law in the greater Atlanta metro area. So the whole Atlanta, metro, Georgia area is where we practice.
Wonderful. This is our first guest from Atlanta. I'm super excited. So am I. Now, Jarrod, tell us, how long have you been practicing law?
I'm in my 15th year of practice. So I've got a few years under my belt.
Oh yeah, you've got a great amount of wealth with
Can't you tell based on the hair? I mean, when I first started practicing, I had hair. And now I don't know if that's because I've been practicing family law or if it's because I've been married for the past 11 years, but one of those, maybe both contributed to that.
Yeah, I'm thinking so, right? Yeah. Being an attorney and being married for a long time. What made you decide to go into family law?
You know, it kind of happened. I didn't go into law school to practice family law, but the first firm I started working for was a family law firm, and I just loved it. I'm not like a corporate lawyer where I don't ever see my client. You know, the relationship you have with your family law clients is very one-on-one. It's very personal. I mean, you wear a lot of different hats. You're legal counsel, and you're also the counselor sometimes. And it's just very important work. You know, I help people make sure they get the right amount of assets. I make sure that they're getting treated fairly when it comes to the child support and alimony. And we also work very hard to make sure that children are put in a proper place and in an environment that's in their best interest. So it's important work, and I just enjoy it.
Do you get to see your family more than the corporate attorney?
Yes, okay. I do. Now, part of that, though, is because I have a staff. So I'm not just a solo. I've got other lawyers and staff working with me, so that adds to flexibility of my schedule.
Okay, wonderful. Because I used to work at the Attorney General's office, and an attorney there, she said that she used to sleep actually in her office at sometimes when she was doing corporate law. So I was just curious.
Yeah, those government lawyers have a very flexible schedule, but yes, the private lawyers that work like at big law firms, corporate settings, it's all about climbing the totem pole and getting that billable hour. So not a lot of flexibility there.
That's interesting. Good side note. Yeah, that's good for us to know. So do you think everyone should get a prenuptial before they get married?
It depends. I mean, prenuptial agreements are helpful if you have assets going into the marriage that you need to protect. So if you are not really expecting to grow a lot of wealth during the marriage, or let's say you don't have a business already established going to the marriage, you don't have a lot of assets already going to the marriage, and pretty much everything that's going to be accumulated asset-wise will happen during the marriage, you don't really need a prenuptial agreement. It doesn't mean that you can't have one. So let's say you went to law school, for example, and you're about to start your own practice. You haven't really made a lot of money yet, but you plan on making a lot of money during the marriage. You can still go ahead and get a prenuptial agreement to try and protect some of those assets. So not everybody needs one, but it's never a bad idea to have one if you can get your future spouse to agree.
Okay. What should be included in it, in a prenuptial?
The only thing that prenuptial agreements can address are issues concerning the children. So a prenuptial agreement can never address custody, it can never address parenting time, and it can never address child support. Everything else can be addressed in a prenuptial agreement. So division of assets, alimony, attorney's fees, all the financial stuff can be addressed in a prenuptial agreement. Now, one disclaimer real quick, the advice I'm giving obviously is based on Georgia law. So every state has different laws. Some states are very similar. Some states are a lot different. But the advice I'm giving today, of course, is based on Georgia law.
Okay. Can a person create their own prenuptial?
Well, it's very difficult. Prenuptial agreements are very detail-oriented documents. They have to be prepared a certain way. And there's a lot of case law out there that says everything that has to be done for a prenuptial agreement to hold up in court. So, for example, it's got to have a detailed financial disclosure. So you got to make sure that you have a very detailed financial disclosure. It's got to be fair at the time that it is being entered into. So there's special wording and stuff that you have to put in place to make sure it's done properly. It's really hard to do that if you don't have the legal training. You can, but I think your chances of having it enforced in court are not as good if you don't hire an attorney to do it for you.
So one of the things you did not mention is infidelity, which I know a lot of our viewers want to know. Can you include that in the prenuptial?
You know, that's an interesting question. I actually have done that before. The answer is yes, but you have to do it very carefully. And this was actually a postnuptial agreement. So you've got prenuptial agreements and you've got postnuptial agreements. The time I did it was a postnuptial agreement. Obviously, a postnuptial agreement is after you're already married, you enter into an agreement talking about how you're going to divide your assets. I had a client and her husband was just a serial cheater, so to speak. He had cheated on her many times throughout the marriage, and she had caught him red-handed, and she decided she was going to give him one more chance. But before she decided she was going to give him another chance, she made him sign a postnuptial agreement that says, if I can ever prove again that you have cheated on me from this day forward, then you get none of the assets. I keep 100% of the retirement. I keep 100% of the assets in the house. You're not entitled to any alimony from me because she actually was the breadwinner in that case. So you can. The only burden in doing that is you, of course, have to prove it. So you can put in there that if you ever commit adultery, then I'm entitled to A, B, and C. But when it comes time to enforce that prenuptial agreement, you have to make sure you have proof of the adultery.
How would we get proof of that? Or what?
Well, you know, you got an obvious way. So if you really catch them red-handed, you might have it on video, right? But that would be the best proof. Text messages, social media, emails, purchases for hotel rooms or flowers or dinners that you weren't at is an obvious one. So there's a lot of different ways to prove it.
Wonderful. I'm glad to hear that information. Yeah. The next question is yours.
Okay. So what are some of the things a potential client could do if they're wanting to get a divorce that could help them win their case?
So one of the things I like to tell my clients is keep a journal. A lot of people have things that happen throughout the marriage, and nobody plans on getting a divorce, but things happen and you forget about it. You don't have a record of it later. So if you think that you might be heading towards a divorce situation, it's always a good idea to go ahead and start keeping a journal and keeping copies of any evidence that you may come into. So that way, when you actually file for your divorce and you meet with your divorce attorney and you go to court, you can actually pull out that journal, you can pull out that email, you can pull out that text message and have it available to present to the court.
Okay. Yeah, I love that. This is so awesome meeting with the attorney. Oh, so the next one's yours as well.
Okay. So how much does the average divorce cost with and without children? And obviously we understand that this is Atlanta, but can you kind of give us an idea of maybe universally how much it would cost?
Sure. So I'll just give you some examples based on my practice. The cheapest way you can get a divorce with or without children is uncontested. So an uncontested divorce means you and your spouse have an agreement from the very beginning on how you're going to address everything. If you can do that, that's usually a flat fee. And my flat fee at the current time for an uncontested divorce is $2,500. So it doesn't cost any more, doesn't cost any less. And as long as both parties sign, that's all you have to pay. A contested divorce is where you can't reach an agreement with your spouse. So you're actually having to get the case filed with the court, get them served, and start the process. That is a retainer. Most attorneys will ask for a retainer. My minimum retainer is $5,000 for any contested case, and that's whether you have children or whether you don't have children. And then what we do is we just keep up with our time and we bill against that retainer based on our hourly rate. So the final cost for a contested divorce just depends on how much work we have to do to get your case finalized. On average, most contested divorces range anywhere from $5,000 to $15,000. Of course, some are less, some are more. It just depends on how nasty and ugly it gets and how many times we have to go to court and what we're arguing over.
Okay.
And I'll tell y'all what happens sometimes, and it's hard to do. What people need to do in their divorce, and this is a good piece of advice for your viewers, is try to make a business decision when you can. A lot of people go into these divorces and they're just tied up in the emotions. They've got hurt feelings. They want the other person to feel pain. They want to make a point. If you can get rid of those emotions and just look at your decisions as business decisions, your case will be much more quicker. It also costs less money.
Okay. It's really good advice, especially the hurt feelings and wanting to make a point.
Mm-hmm.
That's right. It happens all the time.
I'm sorry. What can I do if my ex is ordered to pay child support, but they refuse or they haven't paid for months?
So what you can do is file what's called a contempt action. So a contempt action is you filing a lawsuit against a person that's supposed to pay, saying, hey, judge, you ordered him or her to pay X number of dollars per month. They are disobeying your court order. They owe me money. So therefore, I want you to hold them in contempt. I want you to put them in jail until they pay. And also want you to make them to have to pay my attorney's fees. And that actually is a very good incentive to get people to pay. I've put a lot of people in jail that have refused to pay child support, and it's funny. People don't have the money until they go into the pokey, and they're usually out within 24 hours. Now, there's exceptions to that. Some people don't care. I mean, some people just for the spite of it don't want to pay. What the judge can do, at least in Georgia, other states are similar, is put them in work release. So in other words, you put the person in jail, they've been in there for a month, they still haven't paid. The judge can actually put them to work, put them in a work release program where they get out of jail during the day, they work, the money goes to pay the child support or the alimony, and then at nighttime, they bring their toothbrush back to the jailhouse and spend the night at jail. So that works too.
We need to move to Atlanta.
So, something. So this even includes, say a situation where the person was ordered to pay student loans. Is that something that they can also be held in contempt of court if they didn't pay those?
Yes. The judge can hold you in contempt for anything that you're not abiding by in the court order. So anything at all that you're ordered to do, if you don't do it, you can be found in contempt.
Okay. Is there any way to get assistance from an attorney if I'm a housewife and the only income I have coming in is my soon-to-be ex-husband?
You know, those are the toughest situations, and I hate those situations. I had one of those situations in my office today. You've got a situation where your spouse makes all the money, they control all the money, you don't have access to the bank accounts, you don't have a job. How do I come up with a retainer to hire this attorney that's awesome, that's going to help me out? And most attorneys are going to require that you pay at least something to get started. That's what I try to do with my clients, is I will find out what's the least amount I can take from them up front just to get that process started for them, get the case filed, because once I file the case, I can ask the judge to order their spouse to pay for my fees. So usually what I'll do is I'll cut my clients a break on my retainer and charge them the least amount that I possibly can, whatever amount they can come up with from friends or family members, just to get the process started and then get the judge to reimburse those folks and ask for the spouse to pay my fee.
That's a great way to do it.
It's a good idea. Now, what if you have a client who they're still, like they are a housewife, however, they know their husband's income well enough to know that he wouldn't be able to even pay, but they really want to get this divorce, or maybe they're in a situation where there's domestic violence. Do you ever advise clients on other attorneys that can help them or things like that, especially with the domestic violence?
Sure. So there's two questions there. First of all, there are attorneys that work for legal aid. Most counties throughout the whole state have a legal aid department. They have certain qualifications, certain income requirements, but if you meet those requirements, you can actually get an attorney provided by the county at no fee. Now, not everybody's entitled to that. Only a small percentage of the population will meet those requirements. If you can't meet those requirements, you always have the option to represent yourself unless you can find an attorney that's willing to take your case pro bono. Pro bono means free. Most law firms take a very small amount of pro bono cases per year. So you can reach around to several different attorneys and see if they can fit you in as a pro bono client. If you can't find a pro bono attorney and you can't find legal aid, you either got to represent yourself or try to come up with something, somewhere, somehow, GoFundMe, whatever you can do to come up with some money to get somebody to help you with your case. Some cases you don't need an attorney for. I mean, if you don't have any assets, you don't have any kids, you really don't need to spend the money to pay for an attorney unless you just want that luxury, because having an attorney really is a luxury. Not everybody can pay for that. But if you have complicated division of asset issues, if you have alimony issues, if you have custody issues, child support issues, if you can afford it, it's always best to get an attorney.
Okay. Thank you. Now the domestic violence question that you just asked.
Yeah, that was part two, so I forgot to answer.
If there's domestic violence in the marriage and the client is in fear for their life, do you advise on such situations?
Yes, so there is a process called a protective order. And you can go out and get a protective order if your spouse has been guilty of family violence. So family violence would be physical abuse, it could be harassment, it could be stalking, it could be damage to property. Let's say you're standing in the living room and your spouse picks up the plate and throws it against the wall and smashes it right side of your head. That would be family violence also. So number one, you call the police. The police may come out and arrest them on the spot. If that does not work, you can go apply for what's called a protective order. And that's a process where you go and you meet with the judge. Your spouse is not there. You tell the judge what happened. If the judge feels that an act of family violence has occurred, the judge will issue that restraining order right then and there, and they will go serve your spouse. Your spouse will be immediately kicked out of the house, and then there will be a hearing scheduled about 10 days later where everybody has to come to court, both parties, and the judge decides if that should stay in place. So those are the steps you should take if you're facing domestic violence in your marriage.
And what about information as far as what are people that can help them? Do you have information like that in your law firm? You know, like domestic violence shelters or anything like that? Or do you just...
There are domestic violence shelters. Most counties have a domestic violence shelter. Everybody's welcome. So it's not like they're going to turn you down. Anytime somebody that's an abusive spouse needs to seek shelter and a domestic violence shelter, you can go seek that. Short of that, you just need to get a restraining order against that person and call the police.
Okay. Okay. Do you ever advise marriage counseling? Do you ever?
I do. And that's a good question. I can tell when people come to my office whether or not they're ready to file for divorce or whether they're not. There's a lot of people that come to my office and they are over it, right? I mean, I hate this person, they are the worst thing ever, and I'm ready, and I just want to bury them. Okay, those are the people that I don't refer to counsel. But the people that come in, you can always tell when they're not ready, and they're here just to kind of figure out, if I were to go through this process, how would it look? What am I entitled to? What should I be worried about? And I always refer them to counseling. And what I tell people is, don't give up too easy. A lot of people think the grass is always going to be green on the other side. So unless you've got a major issue, such as adultery or violence going on, if you think that you might still have some love for that person and there might be a future there, give it a shot. Go to counseling. As long as both parties go, it might work out. Now, if you're the only person sitting in the counseling office and your spouse refuses to go, that's not going to work. It takes two. I refer people to counseling all the time. And what I say is, look yourself in the mirror. And if at the end of the day you can say you've done everything you possibly can to make this work, but it takes two, you've done everything you can at least look yourself in the mirror and feel good about yourself, knowing that you've done everything you possibly can, and divorce is your only option that's left. Now, if you've got domestic violence or adultery, or you've got a spouse that's not giving you access to the finances, or there's emergency issues concerning the children, I don't send those people to counseling. They need to get their case filed and get an order in place. But everybody else, I think it's great. Society needs more couples staying together as opposed to people getting torn apart.
Okay. Well, yes, and you're a good example of that. 11 years, right?
11 years, going strong. Hi, Lauren. Lauren's my wife's name.
Oh, okay. So that's the question I was going to ask next. Since you specialize in divorces, do you think people should not get married so that they can save money, or do you think there are more benefits in being married? Sounds like you just answered that question.
I still think there's a lot of benefits to marriage. There's number one, there's a lot of tax benefits. I think that society is still to the point where they recognize and look more favorably upon married couples than they do couples that are not married. I think the research also would show you that married couples tend to be more successful in society. They just do. They get better opportunities. They get better treatment from their peers. So there's just a lot of pros, I think, still to marriage. Now, there's some pros not to getting married, and I think the millennials, what the research is showing is that they're not getting married. They're not having kids either. They're not really worried, frankly. But society as a whole, I think marriage is favorable for society.
Okay.
And especially when you have kids. I mean, think about the kids. If your kid is in a classroom full of a bunch of other kids, and most of the kids that are in that classroom have an intact household, and their parents are married, and they hold themselves out as being a together family, and your parents maybe aren't married, you might feel as a child a little bit of an outcast from that. So unfortunately, I think there's still societal pressures that look favorably upon marriage.
I agree with you. Yeah. What are your thoughts on marrying a foreigner? Some people get married to someone from another country and later feel like they are not compatible because of spiritual beliefs or religious beliefs or cultural beliefs. Some even get divorced and they felt like they were used for citizenship or for monetary gain. How can a person protect themselves from being used in that type of situation?
Well, or in this situation.
Well, with this particular situation,
We know someone.
yeah, we know a few people like that.
Yeah, and I've had lots of cases like that, and a lot of people rush into marriage. I mean, let's just be honest. You know, they fall in love. Everybody knows that feeling when you have new love, right? Everything's exciting and you're anxious. You got that butterfly feeling in your stomach. Can't wait to see the person. And a lot of people just rush into marriage. Date the person that you're going to marry for a long time. Know about their family. I can't tell you how many different divorces I've had because the families don't get along and they intervene and they cause stresses upon the married couple, right? So not only do you want to know about your partner, you want to know about their family. You want to know about their finances. You want to know about their criminal history. You know, you got to check people out before you get married to them. Marriage is a big deal, so don't rush into it. Other situations I've seen, like you said, people will get married for citizenship reasons. So, you know, you've got somebody who's an illegal alien and they're looking for a United States citizen to marry so that they can get permanent residency. You can usually scope that stuff out. If you stay with somebody long enough, they're probably going to leave if they're just looking for citizenship, right? Because that's something they're trying to do quickly. So you don't want to rush into a marriage with somebody who's an illegal immigrant. You also have a lot of arranged marriages, believe it or not, mostly with Indian couples. I've had a lot of Indian divorces where the families have arranged the marriage, and those end up being a disaster. You want to talk about a family ruining a marriage? That happens a lot in the Indian culture.
Yeah, I think that's a really interesting question.
Brian, I didn't even consider that because you think when it's arranged, then they kind of usually stay together. At least that's what's portrayed.
Yeah, I guess not.
Right.
Yeah, the arranged marriages, they kind of don't even know each other. So the family kind of picks them out and pushes them together, and then the family ends up moving in with them half the time. So that's
right.
a situation to thrive.
Mm-hmm.
Yeah,
that's interesting.
So, like, how much time are you suggesting for
a couple to get to know each other and see what their intentions are?
Right.
Yeah. I don't think there's a magic number. You know, that just kind of depends on your circumstances. If you've got a partner that's very open and forthcoming and, you know, they're willing to show you their finances very quickly and let you meet the family quickly, you might can do that within 6 months to a year. If you've got somebody that's secretive and, you know, kind of keeping everything to the side and they're not open and there's a lot of excuses every time you try to get a little more intimate and up close, that might take, you know, 3 to 5 years and maybe never would be my suggestion. But just really.
I agree. We have all red flags,
right? We have another. She said that she got married and on her wedding night, her husband told her that he would not have sex with her, and then he went like for years without having sex with her. Is that grounds for a divorce?
It is. It is grounds for a divorce. So failure to consummate the marriage actually also can be grounds to have the divorce annulled. So that would actually be called an annulment situation. Lack of sex at all during the marriage is grounds for an annulment, believe it or not. And an annulment means that the divorce, you know, the marriage never existed. So legally, the marriage never existed at all. But most states now, you don't have to have a reason for divorce, which is the good news. It used to be back in the old day, you had to prove a reason to get divorced. There had to be adultery, there had to be financial irresponsibility, there had to be, oh goodness, what were some of the old grounds? Lack of consummating the marriage. You had to prove a fault ground for divorce. Now, anybody can get a divorce for whatever reason they want. You do not have to file on the fault ground. You can just say the marriage is irretrievably broken and I want a divorce and you're entitled to one.
Great.
Now, have you ever?
Like, yeah, get me the hell out of that. No, just
Have you ever seen a situation, and this just came to mind, where the judge thought that the couple should work it out and did not agree with them getting a divorce? Does that even happen, or is?
No, by law, judges now cannot do that. They cannot require parties to stay married. The only way a judge can make you stay married, and I've had cases like this before, if you file the divorce on the grounds that the marriage is irretrievably broken and that there's no hope for reconciliation, that's the no-fault ground for divorce. If you have sex with your spouse while the case is pending, then the judge can dismiss your divorce.
Wow.
Because what the law says is, okay, if you're saying the marriage is broken and there's no hope for reconciliation, why are you guys having sex with each other, right? So the judge can dismiss the divorce at that point. But short of that, the judge has to grant the divorce.
Wow. We're just finding out so
That's
much
interesting.
juicy information in this interview.
And I'll tell you all a funny story. I had a case where I represented the wife, and we got an order in place called a temporary order that was great for her. She was getting a lot of money from him. She had custody. She was in the house. He was out. Well, he cozied up to her after that order got put into place and duped her into having sex with him. As soon as they had sex, he turned around, filed a motion with the court, asking the court to dismiss the case because he wanted that order to go away, and the judge had to grant it. And then the very next day, he went and filed for divorce.
Oh, that's horrible.
So don't have sex with your husband or wife if you're in the middle of a divorce, especially if you have a court order in place.
Yeah, we just learned something new.
Yeah.
Stay the hell away. Wow.
That's so funny. Well, we just learned something about trickery.
Yeah, well, we should know. They already come up with enough tricks.
That's right.
Woo! Okay, what can a client do if they believe their spouse is hiding assets from them? Can an attorney locate assets, or is it the client's responsibility to locate them?
So I frequently help my clients locate assets. That's one of the big things that we do in divorce cases. I send out a certain set of requests to the spouse, asking them to produce copies of bank statements, retirement account statements, pay stubs, tax returns. Once I get that information, I can subpoena from institutions any documents that I need. So let's say I have a client that comes to my office and she knows that her husband has an account with Charles Schwab. She's not sure what it is, but she's seen a Charles Schwab statement come in the mail at some point or another. I can send a subpoena to Charles Schwab, and they'll have to send me copies of all the statements. I can send subpoenas to Bank of America, Wells Fargo, anybody that you'd like. I also can hire a forensic accountant, and the forensic accountant can go through all of the records and the tax returns and the pay stubs and the bank statements and actually trace where money has been transferred to and where it's been spent. So some cases that have a lot of assets involved, we actually spend a good amount of time doing that.
You're no joke. No joke.
Look, we want the other side to settle, right? I mean, if I ride them hard enough and I'm doing my job and I'm crossing my T's and dotting my I's, that other side's not going to like me too much. And they're probably going to come begging at the table saying, can we get this case settled, please? So as long as you're handling the case correctly, you can usually get it settled.
Okay. I can have a bit of a controversial question for you. So what if a client is feeling uncomfortable, or she's a potential client, with her current attorney, and she's invested, she's done the the upfront fees, and she just doesn't feel like her client is doing some of the things you just discussed?
Her attorney.
Yeah, or sorry, her attorney. What would you suggest? I mean, could you take them on? Would you would you give them some time to come up with your initial fees?
Sure.
Would you go to a different attorney? That's what you're asking?
Well, if she doesn't feel like her attorney did any of the things that you just discussed, and she feels frustrated, she doesn't feel like she's getting anywhere in court, or he. How do you feel about clients jumping from attorney to attorney?
Well, okay, so anytime you don't feel comfortable with your attorney, especially in family law, you need to get a new attorney. I mean, like I said earlier in the interview, your relationship with your family law attorney is very close. It's very personal. You got to have that good, warm and fuzzy feeling. You got to be communicating well with your attorney. You got to feel like your questions are answered and that they're crossing the T's and dotting the I's. If you don't have that feeling, you're not going to be happy with the outcome of the case. So you're allowed to switch attorneys anytime you want to. Once you start with an attorney, you're not stuck with them. You can jump ship and hire the next guy. But what I also tell people is interview several different attorneys. Before you pick your attorney, interview more than one, because every attorney's got a different style. Every attorney's got a different personality. Every attorney's got a different roadmap for how they think they should handle your case. So you got to go with the person that you feel the most comfortable with. And if you only met with one person, you don't really know what the other options are that are out there.
That's true.
What's a postnup? I've always heard of prenuptials, but I have no idea what a postnup is.
Sure. A postnuptial agreement is just like a prenuptial agreement, except it's entered into after the marriage. So believe it or not, you can do an agreement after you're married that dictates how the finances are going to be divided, whether or not there will be alimony, and also addressing the issue of attorney's fees.
Okay. I have a question. Like, say I get married and I don't have any assets, and then eventually, I inherit some. Will my husband be able to take those assets away from me? Like, if I inherit a home or properties?
Good question. I that earlier this week. Under Georgia law, any asset that you inherit during the marriage is your separate property. So your other spouse has no claim to that property unless you do something to convert it from your separate property into marital property. So the question is, how do you convert this inheritance money, which is my separate property, into marital property? If you put your spouse's name on it. So let's say you inherit the money, you put it in a bank account that has your spouse's name on it. Now you've just gifted half that money to them. Let's say you pass money. Yeah, you don't want to do that. You don't want to do that. Let's say that you inherit the money and you buy a house and you put your spouse's name on the house. Now you've just gifted half of that money. So anytime you receive an inheritance or a gift during the marriage from a third party, keep it separate. Keep it in a separate bank account. If you buy a piece of property with it, make sure you don't put that person's name on it.
Oh my God. Okay.
Yeah, I
Take
have
heed to that.
along those lines, if your spouse, you own the home, you guys get married, and then 7 years later, your marriage doesn't work out, you file for divorce, does he have any rights whatsoever to the home that you shared, even though you were sole and separate property from the beginning?
Okay. If you owned it outright, no. So let's say you bought the house outright and you didn't owe a mortgage and you made no improvements to the house using marital money during the marriage. It's still your separate property. You could be married for 30 years. And if the house was paid off before you got married and you didn't use any money from your salary that you earned during the marriage to make any improvements to the house, it's 100% your separate property. What you frequently see is you'll see people that get married that own a home before they get married, but it's not paid off yet. But then during the marriage, they pay down on the debt. That piece of property has both a premarital separate property component and a marital component. So in other words, all the equity in that property as of the date of marriage is your separate property. Any additional equity that's been accumulated during the marriage based on paying the mortgage down during the marriage would be marital. So that's a hybrid. And that's what you usually see.
Okay. And it doesn't matter if the spouse didn't work or he worked part-time, as long as there was that time frame in the marriage together, that's still considered a marital asset.
Yes, everything accumulated during the marriage is marital. And it doesn't matter if one party earned all the money and the other party was a stay-at-home mom or a stay-at-home dad. Anything earned during the marriage is marital. And I'll tell you who struggles the most with that. It's my female clients. I have several female clients in the past that were the primary breadwinners. And they earned all the money, and they said my spouse was a sorry, lazy SOB and sat on the couch all day and didn't contribute anything to this marriage, and I'm not giving him a dime of my retirement. Well, they usually have to give up some of that retirement. For some reason, it's harder for women to do that. Women that are primary breadwinners do not like to give up that money that they've earned, but the law applies equally to both spouses. Now, I will say this. Georgia is an equitable division state. Now, that's different from some other states. Arizona, I'm not sure, it could be a community property state. Do you guys know which one Arizona is?
Community property.
Okay. So community property is different from equitable division. Community property means anything that you've got is your spouse's, period. It doesn't matter what you had before the marriage. It doesn't matter if you earned it during the marriage. Once you get married, it's marital property. All right? And that's automatically divided equally. Georgia is an equitable division state. So anything you own before you got married is your separate property. Anything that comes in as an inheritance during the marriage is your separate property. And when the court divides assets, even the marital assets, it's according to equitable division, which means according to what's fair. So in Georgia, you can argue, if you have the right set of circumstances, that it's not fair for your spouse to get the same amount of the marital assets as you. Maybe they were guilty of adultery, or maybe they really did nothing during the marriage. Maybe they just spent all the time out with their buddies and were gone 6 months out of every year fishing. You could argue under those circumstances, Judge, it's not fair for my spouse to get the same amount that I got because it's equitable division. Most of the cases, 90% of the cases, everything still is divided 50-50 in Georgia, but you at least have that argument to make that it shouldn't be divided equally. Can't do that in community property states.
Okay. Now you can't live in Arizona and then decide, well, I'm going to move to Georgia before I file this divorce because their state laws are better.
Yeah, that's what I'm thinking. Like, jeez.
No,
Yeah.
can. As long as you meet the residency requirements. So in Georgia, you have to be here at least 6 months before you file for divorce. So as long as you're here 6 months, you can file your divorce in Georgia, and your divorce will be according to the laws of the state of Georgia.
Interesting. Thanks for letting us know that.
I'm going back to the inheritance. Like, I'm in Arizona. If I got married in Arizona and I inherit like a house or some assets and stuff, so then my husband, if we got divorced, would be entitled to those then?
Well, now I want to refer that to an Arizona attorney. Next time y'all have an Arizona attorney on, ask them that specific question, because I was making general statements about community property states. Arizona may have some exception on that I'm not aware of. I'm just not licensed in Arizona.
Okay. Thank you. That's fair enough.
Sure.
If a person has health issues or is addicted to drugs like steroids, will this affect their custody rights?
Absolutely. If you've got somebody that's got a drug addiction or an alcohol addiction, that's going to affect their parenting time. They might have supervised parenting time. They might be required to undergo a drug and alcohol evaluation and follow all the treatment recommendations before they get any parenting time. So if you're in a situation where your spouse has drug or alcohol issues, those are the types of things that you need to ask for.
But you would also have to prove that, though, right? Just can't accuse someone of
Absolutely.
being alcoholic.
Yeah, everything needs to be proven.
Okay. How do you usually do that? Because a lot of people, they hide their addictions. So how could we prove that they're alcoholic or they're abusing some over-the-counter drug or some prescribed drug?
There's actually a lot of ways to do that. Let's say maybe that person has a history of DUIs. Maybe there's witness testimony, so friends or family members that have witnessed them being under the influence. You, as the spouse, certainly have witnessed a lot of the instances where the person has been using drugs or alcohol, and you could go into court and testify about everything that you've personally observed. If that person has been involuntarily committed or even voluntarily gone into some type of rehab or treatment facility, that would be evidence. So there's a lot of different ways to prove it.
Wonderful.
I'll tell you guys, social media has been just a wealth of information for divorce lawyers. Back in the day, we didn't have text messages and all the emails and social media posts and pictures. You'd be surprised how many different times I pulled something off of social media and used it in a custody case. Wow. So you really have to be careful what you post out there on social media, because it can come back and bite you in the butt.
Okay, that's good to know.
Very good to know.
Look, are there ways to protect myself from having to pay spousal support?
Prenuptial agreement would be one way. Postnuptial agreement would be a second way. Other than that, it's just really going to depend on the circumstance of the marriage. If you have been the primary breadwinner and you've historically supported the family and the other spouse has no earnings history or the ability to make significant income, then you do potentially have exposure for alimony.
Okay. How long should I wait before asking for a child support modification?
So in Georgia, you can actually modify child support once every 2 years. So every 2 years, you're actually entitled to a review, and you don't have to have a reason for it. You can just say, hey, it's been 2 years, and I want the court to re-examine the child support situation. Absent the 2-year rule, you can ask for a modification anytime there's been a change in financial circumstances. So let's say you're paying child support and you lost your job. You can go in and you can modify child support. Let's say you're receiving child support and your ex-spouse or ex-partner just got a huge pay increase. Let's say they got a new job and they're making 3 times what they were making when the original child support order went into effect. You can also modify under those circumstances as well.
Okay. Yeah. Would it be more beneficial to file an at-fault divorce or a no-fault divorce?
It's beneficial to file an at-fault divorce if you have lots of evidence. So let's say that your spouse is guilty of adultery, and that's the reason for the breakup of the marriage, and you haven't had sex with your spouse since you found out about the adultery, which is big. Because if you find out about the adultery and then you have sex with your spouse after you know they've been cheating, the law says you now have forgiven them for that conduct. But let's say you haven't. Let's say you haven't made up and you've got evidence to prove adultery, and that's the reason for the breakup of the marriage. In Georgia, since we're equitable division, that means that you can ask the judge to give you more assets than your spouse should get because they are the reason for the divorce. So the only time it usually makes sense to ask for a fault ground is if you have significant assets to divide and you've got good proof. Otherwise, you might as well just file a no-fault divorce. And you can file both ways. You can file on no-fault grounds that the marriage is irretrievably broken, and at the same time, you can file on the fault ground. You don't have to do one or the other.
Okay. Sounds good to me. How can I go about modifying child custody arrangements if I believe my children are being neglected, or that they are being exposed to multiple women, or if they're being yelled at or screamed at, or if the other parent is smoking weed?
Sure. So anytime you have a change in circumstances negatively affecting the children, you can file for custody modification. So if you've got, let's say your ex-partner or ex-spouse has custody, or even if they don't have custody, let's say they've just got every other weekend parenting time, but they're married to someone who's a drug addict, or someone that's got a criminal history, or they themselves have a drug addict or a criminal history, or something else has happened where the children are getting harmed in their care, you can go back to court anytime under those circumstances and modify custody and parenting time.
Okay. You just need to be able to prove that, correct?
Absolutely. And that goes back to what we talked about earlier. Keep that journal, right? Keep that journal. Keep copies of evidence as you're going forward. That way, when the time comes, you'll have everything that you need.
Okay. I often hear that men, they don't fight for custody of their children if they've been incarcerated, or they've been to jail or prison. Does that automatically mean that they will not be granted custody of their children?
Usually, I mean, if someone's incarcerated, you know, if they're actively incarcerated, they're not even going to have parenting time, right? I mean, if you're in jail, you certainly can't have custody. You probably can't even have parenting time. Now, just because you have a history of being in jail does not automatically mean that you're not going to get custody or parenting time. It depends on the circumstances, right? I mean, if you got arrested 10 years ago for disorderly conduct, and you know you were in jail for a short period of time and you're through with your probation, you've had no other problems, there shouldn't be a problem with asking for custody or parenting time. But if you've got a history, let's say you've been to jail 10 times over the past 10 years and you're currently on probation, probably not likely that you're going to get custody unless there's something majorly wrong with the other parent.
Okay.
So the judge can't order the other parent to take the children to visit the parent that's in jail?
That's a good question.
I've seen that come up a couple times, and in both instances, the judge declined to do that. The judge basically said, we don't think it's in the best interest of the children to get exposed to that type of environment. Now, that doesn't mean that the other parent can't do it if they want to, you know, so if the parent wants to bring the children to visit with mom or dad in jail, you certainly can, but I don't think that's something that the judge would order.
Okay. Often women in domestic violent relationships, they do not report them. How else can a court have evidence that the other parent is abusive?
Well, you know, one way is just the testimony. People that have been abused usually are very detailed and can tell very intimate stories about what has happened. So the first way you could prove that would just be by your own testimony of what you've been through in the past. A lot of times there might be witnesses that have witnessed that. If you've called the police in the past, you could get the officer to come testify or get a copy of that police report. You might have pictures of bruises that you've suffered in the past. You know, as long as you've taken the pictures, then you would have that evidence available. If it was bad enough where you had to go to the hospital to get medical attention because the abuse was so bad, you could actually go and get the medical records. So there's still a lot of ways to prove abuse.
Okay, that's useful information.
On that note, though, I've personally seen this where there was abuse and there was evidence of it. However, the judge didn't feel that the abuse, not that it didn't happen, but that it wasn't a factor in the custody of the children. So when people are in those kind of situations and they're a bit confused because they feel that they have evidence, they have proof, but that the judge still gives custody of or does a joint custody with the abuser and then the ex-wife. So in those situations, I don't know if you've ever seen anything like that. Why is that usually the case?
Well, you know, it's always impossible to predict what a judge might do. You know, lawyers that know their judges well and practice in front of those judges a lot usually have a pretty good idea of what the judge is going to do, but you never know for 100%. What I'm hearing you say is that there's situations where you've got evidence that there's been some type of physical abuse and the judge still gives custody equally to both parties. And so usually when a judge does that, the judge has determined that the physical violence was not directed towards the children. It was between the parties, and now the parties are separated. That has resolved itself. There's never been any physical abuse or violence towards the kids, so there is no concern for that.
Okay. But
I'm not saying that's the way I see it, but that would be how the judge would see it if that's the type of ruling that the judge made.
okay.
I'm surprised though, like if the abuser abuses the wife, the court doesn't feel that they might abuse the children as well, like in the future or when they're in private areas or something like that.
Right.
All the judges,
Yeah.
all the judges that I've practiced before do. You know, you had mentioned a specific circumstance where there was a specific instance where there was physical abuse and the judge still awarded 50-50 custody. So either the judge didn't believe the proof or just didn't feel that the children were in any harm's way. In my cases, I don't know that I've ever had a time where I presented strong evidence of abuse and the judge disregarded it and said, it doesn't matter. I'm still going to let you have half the parenting time and 50-50 custody with the kids. That usually does not happen.
What would you suggest if that situation that she just explained happened, like, and she feels that this other parent should not be around her kids as like 50% of the time because she sees him as an abuser? Is there anything you could do after the judge already decided?
Right, after all the evidence has come to the case and everything has been ruled, is it in her best interest to just let it be and deal with that in silence, or just shell out more money and try to get a better attorney?
Well, definitely get a good attorney, but you have limited options once a judge makes their decision. You can file an appeal, and you only have a certain amount of time to file the appeal, but you have to have good grounds for the appeal. And I'll tell you that judges have very broad and wide discretion when it comes to custody and parenting time. It's very hard to get a judge's ruling overturned on appeal for custody and parenting time. So in that specific instance where you've already gone to court, you've hired the best attorney you can, you presented all your evidence to the judge why that person should have limited or supervised parenting time, and the judge does not go your way, then what you need to do is start thinking about a modification. See how things go. See if that person does what they're supposed to do. Are they abusive to the children? And if so, how often is it happening? And go ahead and document it. And if it actually continues, and after the judge's ruling, that person's abusive to the kids or not probably taking care of the kids, make sure you have your journal, make sure you're keeping your evidence, go hire a good attorney and file for a modification.
Okay. If I'm getting a divorce, I have
a restraining order. I'm sorry, let me add to that. You can also get a restraining order. So if you've got evidence that the dad or mom, the other party, is physically abusing the children, number one, you can report it to DFACS. Okay, DFACS, Department of Family and Children's Services, will come out and investigate. They can remove children from parents' homes if they substantiate the abuse. You can also go and file for a restraining order. And if that's granted, then custody of those children would be taken away from that parent. So you still have options.
Okay. If I'm getting a divorce and I have children, can I move to another state with my children?
So you have to give at least 30 days notice. So the law in Georgia is that if you're going to relocate anywhere, it doesn't matter if it's out of state or within the state, you have to give the other party at least 30 days notice. And what that notice is for is so that the other parent can come in and file for modification if they want to. So you're allowed to move. No judge can tell you where you have to live. But if you're going to move, you got to give the other party notice. And depending on where you're going and what the circumstances are, the other parent may file for modification of visitation or custody.
Now, how does that notice have to be given? Can it be a text message? Can it be in the newspaper?
I haven't seen it done in the newspaper before, but it has to be in writing. And frankly, to be honest with you, I don't think the newspaper would work because your ex-spouse may or may not read the newspaper. I know I certainly don't read the newspaper. So you probably use an email or a text message, something in writing directly to that person.
Okay. Let's see here.
Newspapers are so outdated. On the internet, right?
Nobody, you're right. You're right
about the newspaper. I don't know why I didn't get it.
You still read newspapers over there in Arizona? You must have a good newspaper.
No, I still see some newspapers delivered. I'm like, what are those? Who's that guy out there in the morning?
All right.
Anyways.
Can a parent lose custody rights if they work more hours than the other parent?
Good question.
Well, if they're not able to take care of the children, so let's say you get custody in your divorce and you get a new job where you're having to travel and you have to rely on somebody else all the time to keep the kids, and let's say the other parent's available to keep the children. The judge could modify custody or parenting time in that circumstance. So when you get custody, you're basically getting it because you have the ability to take care of the children. And if you're gone all the time and you're not available and you're having to depend on third parties or the other parent to keep the kids when you should have them, if that is a pattern and it's a long-standing pattern, then yes, you would be subject to modification of custody or parenting time.
And when you say a long-standing pattern, are we talking a year? Are we talking 3 months? Like how long is long?
Well, let's say you're traveling once or twice a year, not a big deal. But if you're gone every week or every couple weeks, if it's frequent and the children are frequently having to spend time with somebody else when you can't because you're traveling, then that would give you some exposure.
Oh, wow.
But for how long of a period? Like say it was just for, say it was in the mornings for a couple of hours to take them to school, and it was just for 6 months.
I don't think the judge would modify under that circumstance. There is no bright line rule, so there's not a law that gives you an amount of time. It's just a case-by-case basis. But under that example you just gave, that's kind of short-term. It's temporary. It's not permanent. I don't think the judge would modify under that circumstance, especially if it's just for a couple hours in the morning.
Okay.
I have a really, really serious question I need to ask you.
You got it.
Where do all the single attorneys hang out?
Well, fortunately for me, I haven't had to do that in a long time. But what I'll tell you is that we hang out where everybody else does, so beware. You don't want to marry a divorce attorney.
Uh-oh.
Yeah, you'll never be getting a divorce.
That's what I was going to ask you. Do attorneys make good spouses?
I think family law attorneys do because I see a lot of examples every day of what not to do, right? I mean, I'm constantly on a daily basis seeing examples of what not to do in my household. So I think that's helpful, at least for me, to reinforce what I should be doing. But every attorney is different. There are some attorneys that are stressed out and they hate their job. They might have addiction issues to alcohol.
I've heard that.
Some attorneys work very stressful jobs. They work very long hours. They don't particularly like what they're doing, and they're more susceptible to violence and stress and coping with alcohol issues. So you really have to be careful. You don't want to marry somebody just because they have a label.
Gotcha. See? We love you for all the wisdom.
And that goes for MDs too, by the way.
That goes for what? What did he say?
That goes for MDs too, by the way. Doctors, MDs.
Oh, MDs. Oh, yeah. They
Don't
sound
marry
good.
the label.
We thought.
I've done plenty of courses for doctors and lawyers. You know, everybody's still a person, so you gotta check the person out.
So how do you keep your marriage positive, and on the right path? You gave us just a couple examples, but what do you do to, make your wife happy or your household happy?
Sure. Well, I'll tell you, the top 3 reasons for divorce is failure to communicate, it's financial issues, and it's adultery. Okay, those are the top 3. So the number 1 key to success, I think, in any marriage is communication. You got to communicate with each other, and you got to take time out for each other, especially if you have children. I've got 3 kids. So my wife and I always make sure that we have date nights, at least once a month. We plan some time just for us. Because it's very easy if you don't do that just to grow apart. And that's what happens in a lot of marriages. People grow apart. They forget what they used to be because they get wrapped up in work or their kids and everything else that's going on, and they don't ever have the us time. So they slowly start to grow apart. So maintain good communication and make some time to spend just with yourselves. Other than that, keep an open book on the finances. Trust. Trust is a big issue. If you're not open about the finances and you're hoarding all the money and your spouse doesn't have any access to what you've got in retirement or in savings or in the checking account, that's a problem. That's going to create trust issues. So maintain open communication about the finances, and of course you gotta keep it in your pants, right?
Yes. or get it chopped off. No,
Yeah, little Lorena Bobbitt action. That would hurt.
It's not family law, that's criminal law.
Oh, how can viewers get in touch with you? If someone
So
would like to hire you or,
Sure, and thanks for asking that question. You can go to my website. It's www.oxlawfirm.com. My phone number is 770-497-8688. So just call me on the phone or go to my website. And if you want to speak with me personally, I'll be happy to speak with you.
Sounds great.
Yeah, you're like the best attorney I've ever met. You're so nice. Yeah, I really think I love his spirit.
Well, I'm impressed. Y'all had some great questions, by the way. I can tell that you guys do this often. You had some very good questions, and I really appreciate you having me on.
Thank you. Do you have any last words for our singles or the people that are about to get divorced?
Yeah, I would have some last words. You need to do a little bit of soul searching. A lot of people, and this is for people that think about getting divorced. A lot of people give up too easy. And like I said near the beginning, the grass is not always greener. I've had clients in my office that have gone through several divorces, and it's because they're always chasing the next best thing. If you make the commitment to get married, you should try and honor that commitment. Unless you've just got a bad set of circumstances going on to where divorce is the only option, make sure you can look yourself in the mirror and say, I did everything I possibly could to make this work, but it takes two, and there's only one of us here that's working on it, so I got to file for divorce. So put your best in before you get out. I would also say for people that are still single, check people out. There's no rush to get married. And if you're rushed to get married, then you're probably doing it for the wrong reasons, right? So check out people, meet their family members, find out about their history and their finances, and just make sure that this is somebody you want to spend the rest of your life with before you tie that knot. If it doesn't work out, I'm always here.
Thank you so much, Jarrod Oxendine. We love meeting with you, and we are so happy that you took the time out your day to share part of your business with us and part of your life.
Yes, thank you very much.
Thank you, ladies. I enjoyed it. Y'all take care.
Thank you. You have a nice day.
You too. Bye-bye.